As usual, just from a housekeeping standpoint, what I'll tell you is at the bottom, typically it's at the bottom of your screen, there's a Q&A or a chat button. Hit that chat button, and during the seminar, you're free to pop an email out there, or not an email, but a chat in that little section there, and that will come to the three of us so we can answer your question during the Q&A session. So we do intend to do that. We're going to answer your questions, and so feel free to fire away and make sure you're asking these questions. I'm going to say right off the bat, this is a complicated topic. The way this slide series is sectioned, we're going to start off kind of slow. We'll get more complicated as we go into it, and we'll get into some more complex stuff at the end. So just buckle in, and hopefully it's helpful. And don't worry if you don't understand all this stuff. We're here to help you. This really is the province of estate planning attorneys. And so if you have one, fantastic. If you don't and you need some guidance, let us know. We don't practice law, but we're here to help. If you have some folks, if you want some introductions, we can certainly make some introductions to estate planning attorneys for you. And we're happy to do that. So we have some great partnerships and relationships with estate planning attorneys, and happy always to sort of make introductions and connections to our clients to help make sure they've got their estate plan in order. So just another little housekeeping edit. I'm your presenter, Jamie Worrell. I'll be the moderator today. I am one of the founders of Strategic Retirement Partners and part of the Northeast team here on the wealth management side that includes Mark Beausoleil and Zach Morris. So those are your other two presenters. We're going to sort of share and pass the baton back and forth here. And Mark is a certified financial planner. Probably has more gray hair than any of the three of us, maybe more hair.
I've got hair. I got more hair, Jamie. Come
on. Mark's a great professional and financial advisor, really well kind of versed in this estate planning topic, as well as the other topics we've talked about in the past. Zach, as well, is another fantastic financial advisor for us. CPFA stands for Certified Plan Fiduciary Advisor. So all three of us are fiduciaries when we serve in that capacity with our clients. And we know that's a question that comes up all the time. So just FYI. So Zach, maybe if you could just go to the next slide, we'll sort of start moving through here.
And I think we're going to hide our video here so we can focus on content, right?
Yep. And just caveat on my tie. I mean, it's holiday season, so I had to wear my holiday tie. So don't worry, this is not my normal tie, but hey, you only get so many chances during the holidays, especially this year. So happy holidays to everybody on that note. You can go to the next slide, Zach. Okay, so what is an estate plan? Let's start with the basics. It's a map, basically. It's a map that reflects the way you want your personal and financial affairs to be handled in case of incapacity or death. In other words, if I'm not around, either because I'm in a coma or I have dementia, or if I'm not around because I've passed away, this estate plan would allow me to dictate my wishes for how I want things to take place in my absence. So, I think it's a really key thing to recognize that this is really a way for you to express your wishes and what you want to have happen with things. I also think, let's start from the kind of beginning, and I don't want to skip over what is an estate, because that's, we say there's an estate plan, but what's an estate? An estate is basically your stuff. Okay, it's your financial assets, it's your home, it's those kinds of things. So an estate is really your financial and other assets, your property, those kinds of things. And so the estate plan is something that dictates how you want that handled in the event of your incapacity, in the event of your death. So those are some basics. Wanted to get out of the way right off the bat. You can go to the next slide, Zach. I always, when we talk about an estate plan, if my wife were to go away for the weekend and leave me with our dog and maybe our kids, she would put a big note together that would say, make sure this happens, that happens, etc. Because she wants to make sure things get done. The dog gets walked, and the plants get fed, and all that kind of stuff. So an estate plan is sort of that kind of a note that you're leaving ahead of time before you go, so that what you want to have happen when you're not there happens. So think of it that way. And there's a lot of detail that goes into this, and a lot of different things that come into this. But who needs a plan? Chances are you do. It's not just for the wealthy, because without an estate plan, you can't control what happens to your property if you die or become incapacitated. It makes your wishes clear. and it helps avoid family disputes. So if there's not clarity on what you want to have happen and your heirs are left to decide that, they may argue over it. They may have some turmoil and some disputes that come up, and you don't want that to happen. So an estate plan clearly establishes your wishes in a legal manner that can't be questioned or changed. Proper estate planning can also preserve your assets and provide for your loved ones after you're gone. So obviously we don't want Uncle Sam to get any more than Uncle Sam's entitled to. And part of estate planning is avoiding taxes or minimizing taxes, obviously in a legal way. So it's especially needed if your spouse isn't comfortable with financial matters. So as advisors, we meet oftentimes with couples who maybe one of them has handled the finances, another one has handled other parts of the household. And so if it's really important to make sure as you near retirement, as you get closer to these things, that there is an understanding among each of you, if you're in a spousal or a partner type relationship where you have joint assets. It's really important to make sure each person knows what's going on. So if the other's incapacitated or passed away, the other person isn't left with this huge void and lack of understanding. An estate plan is especially important if you have minor children. So my kids are all, I think the youngest is 18 now, so I don't have necessarily minor children anymore, but certainly it was very important at that point when they were younger, in case they weren't, I wasn't around to care for them. But an estate plan will help you deal with those types of things. If your net worth exceeds $11.5 million and therefore is subject to the estate tax, then it's definitely important. And even if it's not at 11.5 million, it's going to be important, and we'll talk about why. If you own property in more than one state, so if you have a house on the Cape, or if you have a ski house or something like that, or if you're maybe getting ready to retire and you buy some property somewhere else in another state, estate plan is very important because state laws on what happens when you die are very different, and you need to make sure you provide for that. The other thing is privacy. An estate plan will help you keep things more private if you don't want your affairs out there in the public record. And if you own a business, which is usually an illiquid asset, an estate plan also becomes very important. So you can go to the next slide, Zach. So some basic planning concepts here that we're talking about. Incapacity, healthcare, property management, planning for your death, wills and probate, tax basics, lifetime giving, life insurance, and trust. We're going to talk about each of these concepts today. So Zach, you can go to the next slide. All right, so at this point, I will hand it over and hand it over to Mark, and Mark's going to talk a little bit more about planning for incapacity and some of the things that come into play there. So Mark, you're up.
All right, very good. Thanks, Jamie. We'll talk a little bit about incapacity. So what happens if, it's not so much that you die, but you're in a coma, you have an accident, someone still has to make decisions on your behalf. So that's really what incapacity is. So, one of the things we know is it can strike at any time. We don't know when that's going to happen. So, what would happen if suddenly you don't have a plan and you're incapacitated? Who's going to make decisions? So those categories fall into basically two categories: who's going to make decisions about your health care, and then also who's going to make decisions about your property. So what would happen if you don't have a plan? Well, it could be that one of your relatives might have to go to court, and what the court would do is appoint a guardian, someone to legally act in your behalf to make decisions for you. One of the challenges with that is, that places a tremendous burden on the guardian. How do they know what you want to have happen? And obviously, another problem is, those decisions that they're making on your behalf might not be what you want. So it's important to have a plan. So we're going to break this down. We're going to talk first about healthcare. So if you just kind of go to the next slide here, Zach. So planning for incapacity, what happens? Well, there's a couple of ways to mitigate this. You're incapacitated. What can you do? Some basic things that you can do to at least improve your chances of having a plan. Well, you could establish a living will. And what a living will is, it's essentially you're just putting your instructions in writing. Hey, if this happens to me, and do you want life support or no life support? What should the docs do if this situation happens, that situation happens? It's a legal document that you just basically describe different scenarios where you want to put your instructions in writing. Another alternative to that is you could establish a power of attorney. What is that? Well, it's a document for healthcare reasons. If something, you essentially appoint an agent. So this agent, this person, usually it's a spouse or brother or sister, significant other, they would be responsible to make all healthcare decisions on your behalf. So that's what again, it's you're delegating something to someone else to make healthcare decisions for you. And then the last thing that you have in this category called healthcare directives is a DNR, or do not resuscitate order. And what that basically says, hey, if you're in a coma, or you have a terminal illness, what kind of measures do you want the docs to make on your behalf? So by putting those instructions in writing, it's a legal document, and the docs may or may not do certain things based on your wishes. I think the most important thing to keep in mind about these, what they call healthcare directive, is it's a state-by-state kind of a document. So if you're in Rhode Island, you're in Massachusetts, you're in Florida, Arkansas, every state might have different rules. So it's important to coordinate this with the help of an attorney and understand the state laws that apply to you.
Hey, Mark, quick caveat. Just I mentioned I've got kids. I've got 3 children who are all in college, and something that we did recently was we had these types of things done for our children, because if they're over 18 and they're up away at school and something happens, you don't legally have that right. So just something else to think about. We always think about ourselves and our spouse, but think about that for your kids who are now no longer minors. So just a little practical tip there for you.
Great point. Great point. So planning for incapacity. So this is a situation where somebody has to manage your stuff. So how do we mitigate that if you don't have a plan? Well, there's a couple of ways to work on that. If you can hold your assets in joint ownership, right? So many times, you might own your home if you're a married couple with your spouse. What joint ownership means is both people can make decisions on behalf of their property. So you own a house, husband, wife, either one of them can make decisions on the house. So, there is at least a plan. Another strategy is to have a durable power of attorney. So, perhaps you're in an accident, you're in a coma, someone still has to manage your stuff, right? As Jamie mentioned. So a durable power of attorney, just like we had a power of attorney for healthcare directives, in this case, this person would be able to conduct business affairs on your behalf. So whether that's changing investments, selling property, maintaining property, those kinds of things. And then the last category is a living trust, which is very similar to a durable power of attorney, but this is a document where you would change the titling of certain assets, and you assign a trustee. So a trustee would act very similar to that power of attorney. Jamie will get into that in a little while when we talk about trust, but one of the things to keep in mind is planning for incapacity. The property manager function can be a different person than the person who's got a healthcare decision making. Maybe one person is better for those kinds of things, and you might want someone who's a little bit more business savvy to be your power of attorney and be the trustee of your trust. So again, this would kick in if you are incapacitated. So you're still with us on this earth, but you legally cannot make decisions on your behalf. So now we'll talk a little bit about what happens if you die without an estate plan. So, most of us already have somewhat of a plan, because some property does pass automatically to either a joint owner, or if you're in a retirement plan, you have an IRA and you've assigned a beneficiary. What happens with that asset, it will go to the beneficiary. So when we come on the work site and talk to you periodically, most of us are going to emphasize, have you looked at your beneficiary designation? Is the right individual? Because if you died and you had the wrong beneficiary, guess what? That beneficiary is legally entitled to that asset. So it's important to keep these things in mind and review them periodically. So those assets, those types of assets, retirement plans, life insurance, trust, they're part of your estate, but there's at least some semblance of a plan for those assets to be distributed. But how about the other assets? All those other assets are going to basically get passed along based on what state law governs that asset. So The challenge is the state law in Rhode Island or Massachusetts or wherever you live might not be what you desire. So let's look at that a little bit more detail. So you see an image here, and this is a typical state law plan. They call it, if you die, intestate. I don't use that word because I have a hard time pronouncing it. So intestacy, I guess, is the way you say that. Go ahead, Jamie, help me out here.
You got it, Mark. You're doing great.
All right, good, because I have a hard time with that. But basically, you die without a plan, you die intestate. And what's the state going to do? Well, the legislatures in each state has codified this is what's going to happen with your stuff. So if you look at the image here, your individual dies, and state law might say, hey, the wife gets half, the kids get proportionally, they would get the remaining. Now, you can obviously see there's a problem there, right? Because that might not be exactly how you want your estate to be distributed. You know, maybe your wife is a situation where she needs all of those assets, and the kids would be minors and not necessarily need an asset. So there's obviously some conflict, and it might not be what you want. You might not even know what your state intestacy laws are. So obviously, it's pretty relevant. So how do you avoid this? How do you avoid dying without a plan? What can you do? What's some simple things you can do? And the real basic kind of thing is to establish a will. So we'll talk a little bit about wills. What is a will? Well, basically, it's your plan, like Jamie described earlier. It's your plan put in writing. This is what you want to have happen. It's going to direct. You get to decide how you want your property distributed. It's probably going to be different than the state plan that would govern. It also allows you to name an executor. Who's going to be the person kind of managing this process when you're no longer here? Who's going to be making decisions, following your instructions in the document? Who's going to file the tax returns? Who's going to aggregate your assets? One of the things you need to know is the will must be written and it must be signed by you and witnessed. So it's a legal document, but it's the number one thing you can do to at least establish some semblance of a plan. So what happens if you died? What happens with this plan? Okay, you said, go ahead, set up a will. What happens? Now, if you died, most wills must be probated. Now, that's going to be dependent on how many dollars are in the asset, but you basically go to a court. The will is going to be filed with a probate court. They're going to look at it. If you have designated an executor, they're going to say, okay, this individual, go ahead and do your duties according to the document in the will. So what are some of those duties? They're going to have to do an inventory of your assets, collect all the assets. They need to understand, who do you owe money to? They may have to file, and in fact, not may, they will have to file a tax return, in most cases. And then finally, they're going to have to figure out, distribute property. So as you can see here, if you have a complex estate, some of this distribution might entail selling property, hiring realtors, hiring attorneys. So it could be complex. Typically, this process will last several months to a year, and I'm sure that some of you on this call have been executors in the past. I know I have, and it does take a lot of time, and it can be time-consuming and costly at times.
Hey, Mark, just before we go to that next slide, just another practical tip here. In terms of the executor collecting the assets, paying the debts, filing returns, distributing the property, one practical tip here is to just get your stuff in order, because when you die, if your spouse or the executor has to pick up all the pieces and you've got 15 different accounts and nobody knows what the passwords are, or what your debts are, or what your just property is, it makes it really hard, and it makes it even that much longer of a process. Meanwhile, you're needing to pay bills and manage stuff. So you want to get this thing done as quick as possible. And the best way to do that is to get your stuff in order in terms of consolidating any accounts you have, old stuff you have lying around, put it all in one account instead of having multiple accounts. And then again, bring your spouse or your partner into the picture so they know where all this stuff is hidden. They know how to get it. If you go, it's all there and easy. I mean, Mark talks about having a 3-ring binder that he puts all this stuff in. On our financial planning website, we've got a portal where you can upload wills, trusts, you can aggregate all your account passwords and have it all there. So even if you don't consolidate your assets, you can at least have them listed all in one place. So whether it's an electronic thing through something like that with our website, or whether it's through a 3-ring binder, doesn't really matter. Just make sure it's in order. Do your executor, do your spouse or partner a favor.
Yeah, that's great advice, especially going through the process that I have at one time. Where is everything? You know, do you have money at Vanguard? Do you have money at Fidelity? All those kinds of things, if it's in one place, it facilitates the process and reduces the cost of probate. Because one of the things that happens with probate is, you know, you basically present the information to the courts, and the courts are going to look at the instructions and proceed accordingly. So if we move on here, we'll talk a little bit about that process. We have talked about it. So what are some of the pros and cons of probate? Well, you know, the costs are typically modest, right? But it can take some time. Advantage is, you know, it's under court supervision. So, you know, once that will is presented to the courts, somebody has oversight over what's going on with the settling of the estate. So, you know, that protects, you know, the family to make sure that instructions are being carried out. Another advantage is protection against creditors. So, you know, if you owed money to someone, you know, they have a limited amount of time to present their case against your estate. You know, if you owed somebody $25,000, they can't just wait and 3 years later come back and say, hey, you know, Joe owed me $25,000. There's a fixed period of time, and against a state government thing, maybe it's 60 days to present their case. So that, again, protects the family, protects the heirs. So what are some of the negatives about probate? You know, for complex estates, it can be time consuming. It could also be a little pricey. You might have to pay some fees. There could be delays in transferring, you know, your Fidelity account to another brokerage account. Remember, part of the duties of the executor is to contact all these people, all these institutions. Hey, Joe passed away. He's got an account at Vanguard. How do we retitle this process? So that takes some time. So that's one of the downsides of going through that process. Fees, it could be, you know, again, who do you have to hire? Do you have to hire a realtor? Do you have to transfer property? You know, those kinds of things can add cost to the process. And that's what really we're talking about, is a process. Ancillary probate, what does that mean? Well, if you own property in 2 different states, you would be subject to 2 different probate processes. You have a house on the Cape, and maybe you have a house in Florida. There's 2 different states involved. So that process, that probate process that executor has to facilitate would go through multiple states. So as you can see, it can get pretty complicated if your situation is complicated. And then lastly, this is all public record. Remember, the courts are supervising this process. So, you know, there might be some things in your state you might not want the general public to see. So again, privacy, if privacy is a concern, then probate is probably not the best thing that you want to go through. So the question asks, well, how do I probate? I mean, how do I avoid probate? Can I avoid probate? Well, the answer is yes. Estate plans can be designed to control which assets go through probate and which assets do not go through probate. So again, as we mentioned before, if you jointly own assets with someone, what they call joint rights and survivorship, well, both those individuals own that asset. So the individual that died, the other owner would be able to manage that property, and that asset does not go through the probate process. Making sure that you have the proper beneficiary designations. Again, retirement plans, IRAs, life insurance, those assets have a beneficiary designation. That's going to avoid the probate process. So right off the bat, you have that opportunity. Using trust, and Jamie's going to talk about trust in a little bit, that's another technique that is used to avoid probate, where it's another legal entity, and I'll just kind of leave it there. And then lastly, you have opportunities to make lifetime gifts. So why would you consider doing that? Well, if you make gifts, those assets are not in your estate. So if they're not in your estate when you pass away, obviously that asset doesn't have to go through the probate process because it's not your asset at death. So Zach's going to talk a little bit about that a little bit later, but before we'll do that, I'm going to hand it over to Zach, and Zach is going to talk about the tax man, because believe it or not, the tax man gets involved when someone passes. So with that, go ahead, Zach, I'll take it away.
Thanks, Mark. Yeah, appreciate the information. And in terms of taxes, this is another huge implication thing to consider when implementing an estate plan. And as you can see here, there are three transfer taxes, is what we call them, that are going to be considered. And the first one you see is the federal gift tax. Now, the federal gift tax, that's imposed on transfers that you make during your lifetime. And we're going to discuss this in a little bit later of a slide, but basically you have an annual exclusion amount where you can give a gift up to $15,000 per year as an individual, and that would be you would not have a gift tax imposed on that particular gift if it's under the limit. But the next tax we're going to talk about is the federal estate tax, and then that's the tax that's imposed upon your death. So when you die, and like Jamie mentioned, you're going to have a bunch of stuff and assets. There's going to be a tax on it, potentially, if you exceed the exclusion amount. We're going to discuss that again in the next slide. And then thirdly, the third tax we're going to discuss is the federal generation skipping tax transfer. And that's imposed on transfers to individuals who are more than one generation below you. So as you can see, the example is a grandchild. Basically, that can be imposed during your lifetime and upon death. The idea is, you can't skip that generation and skip over paying taxes by gifting everything to your grandchildren. So that's why that's imposed. But what's really important to consider here and to highlight is that these are all federal estate taxes, federal transfer taxes we're talking about. But if you notice at the bottom here, there are transfer taxes imposed on a state level. And those state exemptions typically are lower than the federal amount. For example, Rhode Island and Massachusetts, the neighboring states in where we're presenting, those are typically, Rhode Island is typically around 1.56 million is the exemption for 2020, and then Massachusetts is around 1 million for an individual, is what I'm quoting. But we can discuss those a little bit further, but that's what we're just talking about now in terms of federal taxes. We're not getting into the estate taxes, but it is definitely something to consider because most people will have to pay estate taxes on your state level rather than on the federal level. So the first tax we're going to get into, like you see, like we mentioned, is the gift tax, the federal gift tax, and that applies to gifts that you give during your lifetime. So like I mentioned before, if you give a gift and that exceeds that $15,000 annual gift tax exclusion amount, so if you give a gift of $20,000, you would potentially owe taxes on that $5,000 above and beyond that annual threshold. Okay, so that's where a gift tax would potentially be imposed. Now, like I mentioned before, there is an exclusion amount and a lifetime exclusion amount. This is $11,580,000. It's the largest, as you can see in the last bullet, in history. So in terms of you having to pay federal or estate taxes, federal gift or estate taxes, most likely you would not have to unless your estate and the cumulative amount of gifts over and above this annual threshold calculates above and beyond 11.5 million. But what's really important to highlight here is that this changes, and we're going to get into that later. This is changing potentially, and well, actually currently, this will change in 2026. These current laws are going to sunset by 2026. So basically, they will revert back to lower rates, which is about half of lower exclusion amounts, which is about half of what we currently see on this screen. They're about 5 million. So the next thing we're going to discuss here is the federal estate tax a little bit more. We're talking about the gifts tax, but now we're going to talk about the estate tax, which is applied at your death. Generally, there are some exceptions, and as you can see, there do not have to be estate taxes applied to transfers to a spouse or to a charity. Okay, so that's very important to consider and understand, because if you are leaving assets to a spouse or a charity, then those would be excluded from estate tax purposes. Also, what's important to consider here is that the 11.58 million excluded, that's excluded from all transfers, gift and estates combined. So your federal tax exclusion amount for estate taxes and gift taxes is combined. So any portion, like in that example I gave you before, that $5,000 will be taken out of this annual exclusion amount. Your lifetime exclusion amount. Okay, so it's important to track. The key idea here is it's important to track if you give above and beyond that annual exclusion amount, the difference, because that number, for that example, that $5,000 will be taken out of this, your lifetime exclusion amount. Okay, and I know Jamie mentioned that in the beginning, this is a complicated topic and I'm getting into pretty detailed examples. So if you have questions, and this might not apply to many people, but if you have questions on this, please reach out. The other important fact to consider with the federal estate taxes is that there's a new feature. And the new feature that was implemented in 2011 is that they are portable. This exclusion amount is actually now portable. So if you did not use any of your annual exclusion, your lifetime exclusion amount, any of that 11,500,000, then you can actually give that to your surviving spouse. So basically, you could potentially double, or that surviving spouse could potentially double their lifetime exclusion amount. Lastly, in terms of taxes, the third tax we're going to consider is this generation skipping tax. Again, this isn't going to apply to most people, but this is for giving something, giving an asset, for example, to someone that is a grandchild or a grandnephew. Anyone that skips the generation, they can consider that a skip person. So that particular exclusion amount is actually identical to your estate and gift tax one. You get the same amount, it's 11,580,000. And unlike, though, the gift and estate tax exclusion, this particular amount is not portable. This generation skipping tax exemption is not portable, like I just discussed with the estate taxes. Okay. Now, I brought this up before, and I just wanted to re-emphasize the importance of it. These change. These exemption amounts change, as you can see here, by year annually, or by legislation. So they can change potentially at any time, but in current law right now, they're going to sunset, like I mentioned. These rules and these annual amounts, these exemptions, will sunset by 2026. So it's important to consider maybe redoing your estate plan if you've done one in the past, when those particular exclusion amounts were lower. Maybe now it's important to revisit that, because these exclusion amounts are so much higher that you will not, in terms of federal taxes, potentially have to pay any federal taxes unless you're above and beyond this particular limit, which, to reemphasize, is the highest in history. So that's what we're trying to illustrate here, is that it's really important, because currently by 2026, we're going to revert back to the lifetime exclusion amount of roughly half of this number. It's like 5.8 million. So Jamie, Mark, any comments before I move on here?
Yeah, just that what that means is a lot more of your estate will potentially be subject to estate tax, and therefore you sort of want to really relook at this stuff in 2026 for sure, or prior to that actually. Because
yeah, again, you know, legislation could change this, and it probably will. I mean, who knows what's going to happen in the future? But I think the basic point here is there are federal transfer taxes, but for most Americans, it will be the state transfer taxes that will probably apply to most. So you want to be cognizant of that when you develop your plan.
Right. Okay. And then now we're going to move on to lifetime gifting, because people then ask, okay, if I am in the circumstance where I'm going to, go past this lifetime limit or exclusion amount, how can I avoid this? Well, you can give assets during your lifetime. So basically, this gives gives you a multitude of benefits, but the one that we're going to discuss is the main one. Is it's the third bullet point. It's going to be removing potential future appreciation of property from your taxable estate. So any of that amount that you give throughout your lifetime, like you see here, and like I mentioned previously, that 15,000. If you give 15,000 every year of property or stock or something that's going to potentially appreciate, then now you're removing that from your estate, and you're giving it also to someone that could potentially need it more than you. And there are also some income tax and transfer tax benefits to that, but we're not going to get into that too much more than we've already had. But basically, there is one con, one potential con, and that is there's no step up in basis, that last bullet point. So what that means is your basis, so whatever you bought that stock at, that will, or you bought that property at, that basis will carry over to the donor, the person that you give that potential asset to. So it's important to consider that, because the contrary is true when you pass away. If you pass away and you have an asset that you bought at, let's say, 500,000, it's now grown to $1 million. That asset will be stepped up in the basis to that $1 million. They call it the fair market value on the date of your passing. So that is, now that basis is going to be lower. So that potential person that gets it after you pass is not going to have a huge tax bill that they'll have to pay if they need to sell that asset for any reason. So that's that's an example, and that's a reason why lifetime gifting is so important. And it could be a really important strategy and unique strategy for an individual trying to achieve some of these goals. Lastly, as you can see here, the transfer, lifetime giving transfers excluded from your gift tax. So like I mentioned a few times, you can give up to 15,000 as an individual annually without incurring a gift tax. And then you can give 30,000 if you're married and file jointly. So the classic example is, okay, I have a child, I'm looking to fund their college plan. Can I give them some money for that? And is that going to be considered a gift? Will that be taxable gift? Well, the answer is, if you give 30,000 annually, or you're married and file jointly, then no, that's not going to be taxed. You're not going to have a gift tax, and you can contribute that much to a 529 plan each year. But what 529 plans, as you see in section 2, the benefit to them is that they offer a feature where you can, quote unquote, super fund the 529, where you can fund it up front up to, if you're married and filed jointly, that $150,000 mark. So the 529 plans in the IRS allow you to fund more if you wanted to fund it up front with that larger amount to potentially grow longer, rather than invest a $30,000 each year as to avoid the gift tax, the potential gift tax. So that's why 529s are this section 529 plans in the IRS code allows you to do that, so you can get more potential growth in the future. The last 2 bullet points: if you do gift anything to school for an individual's tuition, there's no gift tax involved there. And then the other one to consider is if you pay directly to a medical provider for an individual's medical care, then that will not incur any gift taxes as well.
So I think the practical tip here, folks, is make those contributions directly to the school or the care provider, and you're not having to deal with the gift taxes there and using up any of that exclusion. So
exactly. All right, guys. So Jamie, I think at this point I'm going to hand it back over to you, and we can talk about some unique vehicles that can be used to avoid these potential taxes.
Great, thanks, Zach. So we talked about trusts. A trust is it's very versatile because there's lots of flexibility built in there. and there's lots of ability to customize it to meet your needs exactly. So that's a really key point there. Why you would use a trust is because it can help you protect against incapacity, helps you avoid probate, as we said, also can help you minimize taxes. It will allow you, by appointing a trustee, to get professional management of whatever assets you put in that trust, because you can assign that management of those assets to that trustee. And we mentioned it provides safeguards for minors, also elderly parents and other beneficiaries. So you can create a trust that will protect assets for the benefit of those people. Also, importantly, it can protect assets from future creditors. So you can have a trust where the provisions will allow you to prevent creditors from being able to access that trust and those assets. So it's a way to protect those assets that you put inside the trust. And finally, it gives you control over that property. So you maintain that control over that property, which I think is also important. So you can go to the next slide, Zach. This graphic is just a little bit of a kind of gives you some sense of what the parties are. So I'll start on the left-hand side in terms of what's a trust. It's a legal entity that holds property. The parties to a trust are, you've got the grantor, which is the person who gives the money or property into the trust. You've got the trustee, who's responsible for managing those assets inside the trust according to the document. And then you've got the beneficiaries, who are going to benefit from whatever assets are in those or properties in that trust. So those are the three parties to a trust. The grantor gives it, the trustee manages it, the beneficiaries get it. There are two types of trusts. There's living trusts, and then there's testamentary trusts. So a living trust is something that you establish and is active while you're alive, whereas a testamentary trust kicks in after you die. You heard Mark talk about intestacy, and so a testamentary is sort of ties into that same word, and it's a trust that kicks in after you die. There are two types of trust, revocable and irrevocable. Revocable means I can revoke that trust. Irrevocable means I can't. So a revocable trust and an irrevocable trust, there are different implications of that, but with an irrevocable trust, it's sort of finalized. When you make an irrevocable trust, you finalize that gift, so there's different things that kick into play there. But the flow, can you go back to that? The flow goes up here in terms of these graphics. You see the grantor. So let's say you set up a trust. There's going to be an agreement, and that agreement just basically is your letter of instruction that says, here's what I want to happen with anything that goes in this trust. Here's how I want this to be managed by the trustee. Here's how I want the beneficiaries to be. Here's how I want them to get the money. And then the trust property is just what you put into that trust. So think of a trust as a big bucket. Think of the trust agreement as sort of a letter of instruction, and then the grantor is you. The trustee is the person who's managing it, and then the beneficiary, those are the people who they're benefiting from that trust. And all that stuff is variable and customizable, and that's why we talk about it being flexible and versatile. Okay.
Jamie, I think it's important to note here that even though you're a grantor, you can also be the trustee of your own trust. So some people get confused about that. So I don't know if you want to talk about that a little bit.
No, I mean, I think it's true, Mark. You can be the person who puts the money in there. You can then also be the trustee. And then, it doesn't have to be an outside party. There are people who you might know who are personal connections of yours, so you might want to be a trustee, but you might be the trustee yourself. Or there are actually trust companies who are chartered under the laws that will literally serve as a trustee, and then they will interpret the document and then manage it. That there's certainly a cost to that. And it's not typically necessary if you don't have a complex situation, but yeah, good point. Thank you. So what about life insurance? Life insurance is something that actually can, you think about an estate. Well, not everybody has an estate, right? But life insurance is something you can pay for during your life to create an estate after you're gone. So let's say you've got young children, or maybe they're not so young, but you want to provide some money for them after you're gone. Without having people have to sell the assets that you have or hold in order to raise that money to do those things for those people. Life insurance is a way for you to buy a policy that then will kick in after you die, that creates that pool of money that can help you accomplish your wishes after you're gone. A lot of times life insurance is bought to pay estate taxes because you want that liquidity there. But with the exemption going to 11.5 million, that's less and less common as a reason used to buy life insurance, because not everybody has an estate that is that big. But you can still use life insurance, again, as I said, to create that estate for you and your beneficiaries when you're gone. And I mentioned it provides liquidity because it's just money. You don't have to sell anything or raise cash or tap into your accounts or sell property in order to have that liquidity. One thing to note here is if you buy a life insurance policy, it will be included in your estate for federal estate tax purposes, unless you properly structure the ownership. And so that's the next slide, talks a little bit about that, and that's an important part of this. You may have heard of ILITs, I-L-I-T, which stands for Irrevocable Life Insurance Trust. And the way that works is you, as the insured, create a trust, and you name a trustee and the beneficiaries. The trustee then purchases life insurance on your life, and the policy is owned by the trust. And then you, as the insured and the trustee, will make policy or cash gifts to the trust, and then the trust uses that cash gift to pay the premiums on the policy. By setting it up this way, you avoid having that life insurance proceed or that money go through your estate plan and be taxed. So that is a very common thing, this concept of the ILIT, the Irrevocable Life Insurance Trust. These are things that, again, estate planning attorneys can help you set up in addition to any other wills and other power of attorneys that you want to set up when you're doing that. So one little note here, number 4, says that beneficiaries technically can withdraw cash gifts during this limited window of time, which is called crummy rights. And I'm not going to get into that in any great detail here, but they typically don't, because those monies are set aside for a certain purpose. But it's basically a way to get around a loophole in the tax laws. So thanks, Zach. You can go to the next slide. We definitely don't want to get bogged down in this concept. It's pretty technical. But anyway, so what happens at death? The ILIT, so the trust, receives the proceeds of the policy. Okay, and then those proceeds are not subject to estate tax. They are then distributed according to the terms of the trust. Remember, the terms of the trust, that is essentially the written agreement and the document that you put together with your attorney and maybe some other advisors in your family that dictates what you want to have happen to these assets or that property that is inside that trust. And once that, again, the proceeds are distributed according to the terms, and then the beneficiary receives the full proceeds without getting the haircut from estate taxes. So again, a very nice little mechanism for making sure that your family gets the most of those assets. Again, we talked about Uncle Sam and trying to avoid any of those taxes as much as you can. So I think I mentioned before, this is definitely a complex topic. We've talked about a lot of complex things. We talked about gift taxes, we talked about exemptions, exclusions, annual amounts, 529 plans, healthcare power of attorneys, durable power of attorneys, these kinds of things, DNRs. This is complex stuff. It's hopefully this is a good primer for you to give you some thoughts about some of the things that you should be thinking about. There was a headline in the news the other day. If you've ever bought shoes from Zappos or Zappos, I don't know how you pronounce it, but the founder of that company just passed away, and he was in his 40s, and he died. And this person had a net worth well into the hundreds of millions of dollars. So extremely, certainly above that $11.5 million exemption. He died. This is tragic, obviously, that he passed away in the first place at such a young age. He died without an estate plan. So there are lots of examples of people who are dying and have died historically without estate plans. And what happens when that happens is people who are left have to guess what your intentions are or have no control over what happens to your assets because it passes through the state laws or the tax laws. So really important. None of us expects to go or become incapacitated, before our time. But hey, we all know it happens. So get your stuff in order is the main message, and get a plan and share that plan and that process with your significant other, so they're kind of on board to what's going on. Make sure you update that on a regular basis and stay abreast of what's going on, and just touch base with whoever it is that put that together for you or with you. I think these are all things that we want you to be thinking of as you, again, near retirement. So Obviously these are things that as you near retirement, you're getting on in age, and these things become more prevalent, that more closer in the viewpoint, if you will. So we gotta pay attention to them. So if you don't have an estate planning attorney and you're looking for some suggestions or some recommendations, let us know. Give us a call. We're happy to discuss any questions you might have. As you may know, we have relationships with lots of great estate planning attorneys, and always happy to discuss kind of what we know, at least. So I will give us a little bit of time. We've got 6 minutes or so here for some questions. So I'm going to go ahead and open it up to questions. As a reminder, we'd love to hear your feedback. So please let us know if you have any feedback afterwards. So I will go back to some of the questions I got. I'll take them kind of in order. If you establish a transfer on death account for non-retirement accounts, do these escape the probate process? I think the answer is yes, Mark. Just quick yes or no on that, but I believe the answer on that is yes. If you're not,
I believe it does, yes, because you're transferring that asset on death.
That's a way, sort of, again, by title. You can, by titling your accounts a certain way, whether it's joint tenants with in common, or transfer on death. The whole idea there is to avoid that. Another question was about making your child the executor, or your spouse executor, or power of attorney. The idea there is, the question was, since they'll be emotionally impacted on your loss or incapacitation, it could be hard for them to sort of do their job or just handle all the details that Mark referred to. So great point, so the question was, can you, how about selecting somebody else who maybe is a trusted friend, or have an easier time dealing with the drudgery of executing a will, or being firm in your DNR wishes with medical personnel? Those are very, very tricky conversations. I think it's certainly reasonable to think about a trusted friend or somebody that you might want to make your power of attorney, or whatever the case may be. But remember, these are difficult decisions. And I think if you give somebody that role, I think you want to have a really firm conversation, not firm, but very clear conversation with that person who you're assigning this, so they go in eyes wide open and really know and understand what they're taking on if they agree to be your power of attorney, or deal with the DNRs and things like that. So
I'll just jump in. I think you have to look at the skill sets of the person that you're considering. Like I mentioned in the healthcare directives, if someone's got a medical background, someone who can be objective and not too emotional when they might have to make a very difficult decision, you want to kind of think about those kinds of things, because you are imposing a significant burden on that individual. So it's important to talk to that person, consider can they make some tough calls that you may want to have happen.
Yeah.
And then on the other side, with the property management side, who's best qualified that you can think of in your family or a significant friend who can handle maybe financial matters, property matters, and those kinds of things. Yep. They can be different for people, but I think look at the personalities and the skill sets that each individual that you're considering has.
Yeah, and these are good questions that an estate planning attorney or an advisor like us will have experience with. So, I think seeking that guidance from an estate planning attorney is great. Is the gift tax paid by the person giving or the person receiving? The answer is it's paid by the person giving, because the whole idea behind the gift tax is that it's basically trying to stop people from doing an end run on the estate tax by giving away all their money while they're alive, instead of having it pass through the estate tax. Another question was, I'm guessing the $11.5 million exemption will be reduced under the new president. It's definitely possible. We certainly don't know, but remember, it is set to sunset and revert back to almost half of what it was in 2026. So that is coming up.
Too fast.
Yep. Do the tax benefits of a Roth pass to the beneficiary, and can they access it penalty free if under 59.5?
The answer is yes. Yes.
Okay, great. Thank you.
Yeah, because there's a required minimum distribution rule to a beneficiary of a Roth account. So they'll get that asset over time without penalty.
Okay. All right. I guess Zach or Mark, if you see any other questions, I'm just looking to see if there's any that I have not answered. Looks like we have an open question here. Yep, we just answered that one. And so I guess what I'll say is thank you all for joining us today. Hopefully this was helpful. If you want to do it again tonight, we'll be here at 7 o'clock. So, if you're really a glutton for punishment, but if you have further questions, we didn't answer them. I apologize for not having gotten to any that I didn't get to. I think I did, but the other thing I'd say is, at the bottom of the screen, we've got our website there. There's a lot of content on there that Zach referred to. If you go to the resources page, we have a YouTube channel. And then also Zach's email is there as well as our phone number. And happy holidays, everybody. Thanks for joining us. Come see us. We're going to do something on investing because we've sort of talked a lot about stuff other than just pure investing. So we're going to hit that, and it'll be focused more on, how to invest as you get closer to retirement, where we find a lot of people getting very conservative, asking about annuities, asking about bonds, how to do that. So we'll talk about that in probably January or February. So stay tuned for that. Be safe, be well. Happy New Year and happy holidays. Thank you.
Enjoy the holidays.
Thanks, everyone.
Thanks, everybody.